Thank you very much, Madam Chair. Welcome. This question of temperament obviously is relevant. You'd acknowledge that?
Yes, Senator.
Okay. And you made a comment in response to Senator Booker, who was asking you questions, and I'll ask these as well, that complaints were never made ethically, and there'd be a responsibility of an attorney to make those ethical complaints under the Judicial Code. I just have to say I disagree with that. I mean, I was a defense attorney, worked with many prosecutors, had enormous respect for those prosecutors. So the temperament issue doesn't always get into the question of whether it's an ethical violation, but it does get into the temperament and why that, in my view, is very important, whatever our job is, but particularly for a judge where you've got that incredible power. So I do want to go through some of these questions that have been raised by that letter that was sent making some complaints about you. You were described as vindictive. There was references to abuse of power, a refusal to engage in any discussion about the case. And there was one in particular that stood out to me. One of the attorneys in a case involving someone who was detained had information that the person had in fact reported as required. And he was trying to provide you with this information because the hearing about his client's well-being was to take place soon. And it says that you snippily told me that he would not even try to call the PO, I assume that's probation officer, on such short notice after I suggested he could at least try to reach out, and then you might get lucky and catch him. Is that true?
No, Senator, it's not true. And that's exactly the type of issue raised in that email where it's an allegation about an abuse of power that, if
true. So you did make the phone call?
No, the whole episode as described in that email is not accurate. And if
well, I'm not going to know that, and I'm not sure you do, but the basic point here is that you could have made a phone call that would have resolved the situation, whether that his client had in fact reported or had not, and you wouldn't make it. So you're denying that that's true.
I do deny it, and I think the paragraph describes that one of my colleagues stepped in.
All right, let me go on to the next one. Thank you for giving me your answer. The prosecutorial misconduct scandal, that is of concern to me and presumably would be of great concern to you in your job as a prosecutor. And what the judge found, that errors were so severe that following a jury verdict in his favor, the government determined that further prosecution of the case would not be in the interest of justice. I mean, this is a case where there were prosecutorial assets used, there was a conviction, and then the prosecution had to end it, right?
Right, and I was one of the supervisors who participated in that decision because I was so disturbed by the violations that had taken place.
But what the judge said, as I understand it, is that you offered little in the way of supervision.
And so, as I've said, I respect Judge Nathan's decision. That aspect of the opinion.
But he said that, right?
It said that, but it was always difficult for me to square that with the fact that during the operative weekend, on both days, I was with the prosecutors. The record reflects that I spoke to the prosecutors at 10 o'clock on Saturday night, at 10 o'clock on Sunday night.
Well,
so again, I'm not perfect, but I did do my best there. My best wasn't enough, and I acknowledge that. But I don't think it's true that I didn't work hard on it.
Let me go on to a third thing. In 2021, the Southern District's Executive Committee initiated a formal investigation into your conduct. And my understanding is that after that happened, that's when you shortly thereafter left the Southern District. Is that correct?
No.
When did you leave the Southern District?
December of 2021.
December of 2021?
Yes.
Yeah, well, that's shortly after the 2021 investigation. Have you ever been asked or had to take anger management or behavioral management at the Southern District?
No.
All right. Who won the 2020 election for President of the United States?
President Biden was certified as the winner of that election.
So you give the standard answer. You can't say that he won because he got the majority of votes and also got the Electoral College victory?
I think the characterizations that you just made, Senator, are both political, and so I can't address them under the canons, and they're also tied up in ongoing litigation.
Help me understand how it's political to state who got the most votes in any election.
Senator, I'm just trying to be precise. The process by which our country declares the victor in an election is a certification process. President Biden was certified.
Okay.
Thank you, Senator Welch.
Yield back. Thank you.
What you just witnessed in this exchange between Senator Welch and Emil Bove so striking isn't just the tension in the room. It's the way it reveals the stakes of judicial power in this country. People often hear about judicial nominations and think of them as procedural, technical, or distant from everyday life. But this moment shows exactly why they matter. Judges don't just read laws, they shape them. They interpret reality inside the courtroom, and their judgments ripple outward into communities, institutions, and history. And when a nominee struggles with transparency, struggles with acknowledging past conduct, or even struggles to affirm basic truths, that raises questions far bigger than the hearing itself. Senator Welch zeroed in on temperament for a reason. Temperament isn't an abstract quality, it's the foundation of whether someone can wield power responsibly. A judge with a volatile temperament can turn a courtroom into a battlefield instead of a place where justice is preserved. A judge who dismisses concerns, who doesn't listen, or who treats opposing counsel as enemies becomes someone who tilts the scales instead of balancing them. Welch wasn't asking about temperament to embarrass Bove. He was asking because dozens of former prosecutors and defense attorneys had raised alarms. These are people who worked alongside him, who saw up close how he handled pressure, disagreement, and authority. When experienced professionals describe someone as vindictive or unwilling to engage in dialogue, that signals a breakdown in the collaborative structure that makes the justice system function. But it wasn't just temperament. This exchange illuminated something viewers must understand: the enormous weight of prosecutorial discretion. When Welch questioned Bove about cases where misconduct occurred or where oversight fell short, he was pointing to moments where the system itself faltered. Prosecutors hold incredible power. They decide who to charge, what to charge, and how aggressively to pursue a case. When that power is exercised without humility or fairness, people's lives can be upended further by the very institutions meant to protect them. Welch's questions weren't about relitigating the past. They were about determining whether those past lessons were truly learned, or whether they were being minimized to protect an image. And then came the question that should have required no calculation at all: who won the 2020 election? For a judicial nominee, someone who must interpret the Constitution, rely on facts, and uphold reality, to hesitate on a matter that is legally settled is troubling. It may seem like a political trap, but it isn't. It's a test of whether a nominee can acknowledge truth even when it may be inconvenient to certain political loyalties. And that matters more than people realize. If a judge can't clearly affirm the result of a certified election, what happens when they must rule on a case involving elections, voting rights, or political disputes? That tiny hesitation can snowball into major consequences, because courts are the final arbiters when democratic systems are contested. A judge who can't articulate basic truth cannot be trusted to anchor a courtroom in integrity. There's an important lesson here for viewers: transparency isn't optional. When someone is nominated to a lifetime seat on a federal appeals court, the public deserves to know whether their decisions are guided by principle or by pressure. And the best way to measure that is not through speeches or endorsements, it's through moments exactly like this one, where a nominee is asked simple, direct questions and must choose between clarity or evasion. Welch pressed because evasion in these settings isn't harmless. It can signal how someone might behave when no one is watching, when the stakes are high, and when the consequences are irreversible. This hearing also highlights the importance of oversight itself. Without senators pushing for accountability, without public scrutiny, individuals with troubling patterns could quietly ascend into positions from which they can shape law for decades. Hearings like this are sometimes the only opportunity the public gets to see beneath the polished resume and evaluate the character behind the credentials. So the takeaway isn't just that the exchange was tense. The takeaway is that this is exactly how democracy protects itself: by questioning power, by demanding truth, by refusing to let evasions go unchallenged. And it reminds us why these hearings deserve public attention, not as political theater, but as a safeguard for justice. If you want more breakdowns that go beyond the headlines and help you truly understand how these moments shape the country, make sure you're subscribed, turn on notifications, and stay tuned. These conversations matter more than most people realize, and we'll continue breaking them down so you're always informed, always aware, and always empowered.